Okay. All right, so we are live again at our old offices, talking about immigration changes and updates. And we'll wait a few seconds for everybody to come on. And let's see here, just like that. But the premise of the show today is going to be, updates of the week, what happened in immigration, some key points that we haven't covered last time, and it's always exciting in the immigration world, right?
Yes.
We hear. I'm Jacob Sapochnick, and this is Marie Portolano, who is our managing attorney, and every week we gather the most exciting information and share with you. What we're going to do is, hi Mila, hi Upi. We will, you can, as you join us live, you can post your questions in the comments and we will answer them throughout the show. But we're going to start with some of the topics because I know you all want to know the most pressing and most important things that are happening in immigration. So I just read that President Trump met with top CEOs of Fortune 500 companies yesterday, and they just had a dinner talking about different things, and they basically were pressing him on immigration, and they were asking him most of the dinner about immigration, and they actually wanted him to create a program that will allow skilled workers to be able to come here in a much better way. And Trump promised he's going to do an executive order following the dinner, but we don't know if that's going to happen. We'll see. Another important thing that happened was the DACA announcement by a judge beginning of the week that the DACA program will continue. And but of course, there's something that's going to happen today in Texas that may change that. Why don't you tell us a little bit about what's happening with DACA, Marie?
So, if you remember last year, Trump, his administration canceled DACA completely. Around January, they canceled only, they say you cannot file a new DACA, but you can file extensions. So we were very happy about that, and we've been waiting for the Congress to get together and pass a law about DACA, which has not happened yet. So we have to rely on the court right now to get the law. Last week, a judge gave 20 days to the administration to reinstate DACA for extension and for new application. However, I think right now, today, this afternoon in Texas, they are hearing arguments for a case that's probably going to destroy DACA. It's Judge Hannan, and I don't expect him to not go against DACA. So it's going to be a very new, also a constitutional challenge, because one judge is saying, I give you 20 days to bring back DACA, and another judge probably going to say today or this week, destroy DACA. So it's going to be the first time there's a complete opposite. So maybe it's going to go to the Supreme Court, but let's first wait to hear what the Texas judge is going to say.
So as of now, DACA applicants that hold DACA, they can continue to renew it until further notice. But any new DACA applicants, so if you are somebody who will qualify for DACA today, you can't do it until there's going to be some other decision. So obviously a lot of our DACA clients are worried because many of them are working, many of them are contributing to society, and they really can't plan so what would be some advice that you can tell somebody who's in DACA who is uncertain about their future with this program?
Well, I would file my extension if you're within your timeline of 5 to 6 months before expiration. You should start gathering your paperwork and file if you can, because who knows if we can even file extension tomorrow or next week. For the rest, well, I still hope the Congress is going to come up with a law for Dream Act kids. That's still my hope. I don't know if it's feasible, but they've been promising that for at least, 6 months? Since January, they promise the law. Every other week we have a new proposition, project.
Right. So right now it just remains to be seen. And of course, those of the DACAs that are going to marry U.S. citizens, of course, there may be other options for them. But right now, it remains to be seen, and we'll continue to update you. So one of the things that we wanted to talk about today are some green card interview tips. And as you know, no matter what you do, you are, whether it's an employment-based case or a family-based case, all green card petitions are subject for interview. So back in the day, which is less than a year ago, only family petitions, like marriage cases, and most of the family petitions were actually getting interviews. But now, every green card application is subject to an interview, which makes it, first of all, much more complicated, makes the process much more confusing, because even officers are not always aware of what they should be asking, what are some of the standards. So we wanted to kind of touch base some of the points that we've seen recently clients are getting into trouble, and give you tips how you can overcome those issues if you follow those tips. So let's start with marriage petitions and I-64 for joint sponsors. What are some of the issues that we see there, Marie?
So in later, when you get married, and if your husband or your wife is a U.S. citizen doesn't make enough money, you need to, for example, for a couple, if you make less than $20,000 a year on tax, you have to find a joint sponsor, someone who's going to sponsor you, and promise to the government that if you become a public charge, or if you receive food stamps or anything else, they will go after the joint sponsor and get back the money that the government spent on you. So very recently, and it's been at least in San Diego, I cannot talk about other jurisdictions, but they've been specifically asking client, how do you know the joint sponsor? Is it your family, a friend? How long have you known him? If it's a friend, do you know him for 2 months, 6 months, 10 years? They are looking for, I think, and I'm not sure, but I think they think that people are paying their joint sponsor, and it's not a kind act. It's like you're paying him. So they are trying to
stop that.
To stop that, which I don't know how, I don't understand why is a deep reason into that, but we've been observing that in the interviews, the specific question of who is your joint sponsor and how do you know him.
Right. So some of these marriage cases, they're trying to detect fraud, and so they determine that if somebody is willing to sign paperwork and they're not really connected to the couple, maybe there's some sort of something shady going on. So it's just kind of like a red light. So we always tell people, try to find co-sponsor that you know, or at least somebody that you can explain in a logical way why they're your co-sponsor. Maybe it's a friend or family, a coworker or somebody, but not just somebody that you paid, because that's going to create a problem down the process, whether it's your first interview or your second interview. Another question that we see that they ask, and it's a question that is on the form I-485, whether it's for an employment-based or a family case, is whether you violated your terms of your visa. And for example, if you say yes, if you overstayed, and so there's a little bit of complicated issues there as to how you answer. Maybe Marie can tell us a little bit more about that point.
So question 17 on the 45, which is a form for the green card, asks if you ever violated the term of your visa. You have to be upfront. If you overstay, you have to be and say yes. However, we've seen, because we get a lot of phone calls on a daily basis, a lot of people call us and ask us, should I say that I got married within 90 days of entering? This is a very tricky question that you should talk about with a lawyer, because it's not about getting married within 90 days or 60 days. It's about what was your intent when you cross the border. Immigration is going to might look very carefully when you enter and you arrive with your tourist visa, for example. Did you have an intent to get married with a U.S. citizen, which would have been against your visa? Now, if you arrive in the U.S. and, well, things go smoothly and you decide to get married pretty fast, well, that's another story. So just be very careful how you fill out the question 17. because by being too upfront, you might just bring red flags that don't really exist. So be careful to talk with a qualified lawyer.
Right, because some of the way you answer those questions can trigger more investigation for no reason, specifically with the question of overstay. And there's some instances where overstay is not an issue, but you need to know which ones are those instances. Another thing that we've seen is questions about arrest. So as you know, certain arrests and criminal offenses can be a problem for your green card. And so therefore we highly recommend anybody who's going through the green card process, whether it's employment or family, to do a full criminal background, DOJ and FBI, and it's not a complicated process. You can do it before the interview, and this way, when we work with our clients, we can look at that report. But I would say almost every interview, make sure you have that full DOJ, FBI report, because if you don't, sometimes there can be things that can be discovered at the interview, and if you don't see it in advance, it's very difficult to deal with it. It may be already too late at the interview, and sometimes can result in denials or even arrest at the interview. So make sure you have full DOJ, FBI criminal reports done before you actually attend the interview. And any attorney can help you with that. And again, at the end of this, or throughout the stream, we will answer the questions, and you can always make an appointment to consult with us, whether it's the first time you see us or second opinion. We always do that. Please, Marie.
Also, a new term we've observed is in California, you get your report from the Department of Justice, which is not available in other states, but in California we can get it from the Department of Justice. And many, now the immigration here in San Diego has decided that just provided the criminal record from the Department of Justice is not enough, because sometimes, and we've observed that more and more, the Department of Justice doesn't keep a record updated, so it might show that you are arrested and charged, and then there is no disposition. So it brings a lot of problems. That's also why you have to have your report before your interview, because it brings a lot of problems, because they don't know if you are charged, so you have to go to the DA, to the judge, and usually you have 30 days only if you get a request for evidence, so it gets really complicated. We used to be lenient and told the client, well, if you feel like filing your case without DOJ, just do it. At this point, I don't think we ever recommend that or even allow, because it's extremely dangerous to go for the green card or your naturalization.
It's always better to be informed as to what what you have in your criminal record file before you go to the interview, and instead of being surprised there. And again, I see a lot of questions are coming up. We'll answer them in a second. Another interesting thing is about public assistance, public charge. As you apply for a green card, if you take any benefits from the government, food stamps, child insurance, things like that, there could be a bar for your green card. Well, now there's some additional changes that could make it even more complicated if you've done it. And Marie, what are some of the new things that we've seen that they're mentioning?
So Trump is right now reconsidering what is a public charge. He's going to change the definition of what is a public charge. From what we heard, he's going to... So as Jacob said, public charge right now is food stamp, social security income, or stuff like that, like people who are being helped by the government. You are not allowed to receive food stamp if you have a visa or a green card. This is forbidden. Only U.S. citizens are allowed to get food stamps. Only U.S. citizens are allowed to get social security income. If you get it while on green card, you're going to have a lot of problems when you get naturalized. So Trump wants to expand what is a public charge, and he wants to include, for example, Obamacare. Why? I mean, Obamacare is a system. You go through Obamacare and they give you what insurance you qualify for. They want to include that as a public charge. Again, it's in the system. We're going to say children's health insurance. Why? I mean, Obamacare, you have to have health insurance, so it's kind of a cycle. So we're looking on how they're going to redefine a public charge. What is a public charge? And believe me, they're going to be very bad consequences if you ever received public charge.
Right. Again, things that could result in denial. Mm-hmm. Another thing we've seen they are concerned is, have you lied, concealed, or misrepresented any information? And again, it goes back to when people Like when you come to and enter the border as a visitor, you state something at a port of entry. Yeah, I'm coming just to visit. I'm just coming to see my sister, my brother, or whatever. And then when you come as a tourist, you change your status and you become a student, or you marry somebody. Well, those things now could be used against you at the interview, because they're going to say, wait a minute, we have records that a year ago, 2 years ago, you told us that you're just going to be a visitor, you're going to go to Disneyland or to Vegas to gamble, and now you're married, or now you're doing something else. So those things could be an issue, and people can start being charged with misrepresentation. And we've seen things that are happening right now. So be aware as to what you tell them at the border, and keep things short. Don't reveal too much information, because the more you say, the more they take from you at the port of entry or any other place that documents that kind of info can be used against you afterwards in immigration proceedings and immigration interviews. Do you want to add anything to this point?
Well, be careful when you, it's called a DS-160, when you apply for a visa at a US consulate, you have to file a form. The DS-160, they ask for all your employment, everywhere where you lived. They've been actually going back to the DS-160 you submitted 5, 10, 20 years ago, and they're going to look, what did you say, where did you live, what did you say you work, and then they're going to match their record. Did you come as a B2 and you say you live in America? You're getting a fraud, inadmissibility, a write-off, and you're going to have 45 days to do a waiver.
Which is hard to fight.
Which is very hard to fight in 45 days. So be also careful what you write on your DS-160 when you apply for a visa at the consulate.
Right. So, as a whole, we see a lot of changes in those green card interviews. They become much more tough. They go into more detail. They can look at people's appearance. They can make assumptions, because remember, before, especially those employment interviews, there was no interview. So they would look at the paperwork. They would see if somebody has a degree. If they work somewhere, they would just approve it automatically. Now, you can say something in the interview that is not going to look good, and it will open an assumption of fraud. They're going to investigate. So we've seen a very, very complicated turn of events, and we are really preparing our clients for interviews as if we're going to court. Marie, what are some of the things we've seen that are happening? And then we're going to go into questions.
Well, for employment, it's a very complex subject. And officers, they're trying very hard, and they are trying, but they don't understand most of the visa, H-1B, TN, E2, they don't understand much. So it's very difficult to deal with them between the officer who is overzealous and wants to find every little detail of all your stay, that if you ever overstay 1 minute in the past 20 years, to the person who will understand nothing and just look at your last I-94 and don't understand anything. So it's been sometimes very challenging, and you have to go with a good lawyer, because I've had a client come from other lawyer who, for example, he was an EB1A, so he had extraordinary abilities. And the officer started to ask, where is your affidavit of support? We talked about that, this is I-864. However, you don't need an I-864 when you have an EB1A. It was a self-petition, and EB1A doesn't require affidavit of support. The lawyer didn't stop, and he opened problems, and we got RFE after RFE for nothing. Like, you should have just stopped because you don't need an affidavit of support. So, right. Just because they don't know, and it's okay they don't know, but they need to be educated. They're still very untrained, and hopefully with time it's going to get better. But for now, make sure you go with a
right.
skilled lawyer.
So again, it's just to show that things that are happening at the actual interview can change the course of the case. So if an officer determines that they pick on something that you said, or they look at the paperwork and they decide that something is not right, they can change the course of the case right there at the interview, which wasn't the case before, especially for employment-based cases that typically were almost approved automatically once they got the paperwork. So preparation for those new kinds of interview is really essential right now, and we are, obviously studying and improving our process and how we are educating our clients and how we are working with our clients and how we conduct ourselves at those interviews is going to be really important. So let's take a look at some of the questions, because I know you wanted to ask some of those. Let's see here. Okay. All right. So let me pull some of those questions. So we have. Let's say hi to to Upi, to Mila, to Edmundo, to Monica Rodriguez. Ryan is in the house. Monica is asking how long it's taking at this time to get approval on I-601s.
1 year.
About a year, right? So we've seen about a year plus on 601As. Yeah, it's about a year. We don't think there's going to be anything to make it faster. And again, now is the time to ask your questions, and even at the end of the stream, when we're done, we'll continue to answer those questions on that post. Amara Joy is asking. She just says hi. Hey, hi. Mitch is saying hi. Yari Tamao is saying, hey, can you help with me with my husband immigration case? Absolutely, Yari. So if you need help, just send us a message, and I'm also going to put my my email address here, and you can actually send us an email if you need assistance. And again, we're open for consultations. And here we go. So we definitely can help with your husband. Meha Jani is asking, what is the average amount of investment needed for an E2? I mean, again, there's no set amount for an E2 investment, but we always recommend at least $100,000. And again, it depends on where you are, what state, things like that. Meha Jani is asking, my husband is looking to create a business within San Diego, within health and fitness. Can I qualify under the same visa and still work and educate myself? For sure. Your husband can get an E2 as a principal, and you can get an E2 as a wife, and you can get a work permit, and you can go to school and do whatever you want. So if you are watching this now, send us a direct message or email me, and you'll get a special price on your E2 visa just because you're watching us live. Joel is saying hi. Hi, Joel. Blush, please tell me how much time to approve F2B category visa while petitioner is a green card holder. I think it's about 2 years plus, right, for F2B, for a green card holder for a spouse? At least 2 years. Yeah, at least 2 years. Hello, Ahmed Yunus. I have been waiting for administrative processing over 8.5 years. Any advice? Well, unfortunately, some of those cases take forever, especially from certain countries. Because this is very case-specific, I encourage you to send us a private message, Ahmed, and we can definitely take a look at it. We've done quite a few work with the embassies all over the world to push those admin reviews, and with Washington. Again, every case is different. But again, send me a private message. And it's very important for you to understand that we're doing this as a public service to you guys because you follow us on Facebook, and some of you are our clients. We're not your attorneys, and please understand that we are not providing legal counsel. This is just general information. But Ahmed, please send us a message, and we'll be definitely happy to help you. Blush is saying the priority date is September 2013. Again, it's a case-specific request. We'll be more than happy to look at it. If you send us a private message, we can take a look at it. Again, there's a visa bulletin, and in the visa bulletin there are different dates, and based on that date, it depends how long you have to wait. Thanks, Meha. I'm more than happy to help you. And I remember you just put in the title Facebook Live consultation, and you get a special price. Monica, oh wow, what happens after you pass the 1 year mark when it's I-130 was processed? Does it just get canceled? Well, it's important for you to keep your I-130 alive, and there's a way to ask for them to extend it so they don't cancel it. So that usually the MVC will send you an email to let you know that it's going to expire. There's a way to keep it alive. Any other tips on that, to keeping the I-130?
You have to call the NVC. There's a phone number. Call it around. The best time to call is like very late at night, around 10 p.m. Pacific. So 10 p.m. Eastern time. You call them and just give a phone call, and it's gonna keep your I-130 alive. You just have to contact NVC once a year, and then you go back to 1 year on your I-130. For some cases, you have to email your NVC. So I don't know where you're from, but give a phone call. They are very, very helpful.
Yeah.
But make sure you call them before the I-130. Not the I-130, but before. You look at the last time you contacted NVC, and then within 1 year you have to contact them again to keep your I-130 alive.
Right. And again, if you need help with that, that's what we're here for. Dashmore says hi. Hi, Dashmore. Dele Eribo. If you want to apply for EB5, but you're an OPT STEM and only have 6 months left, would it be possible to stay past the end of the date? No. So EB5's, the first step takes about 14 months at least. And so you have to find either you have to go back on F1 or find another status. I would just recommend for you to go back on F1 if you can for another year. Right now, EB5's, we're waiting for a September extension, hopefully. The future of this program is uncertain, so if you are ready, do it now. And again, daily, because you're watching this broadcast, you get a special free consultation on EB5, which typically we charge. And I'll be more than happy to kind of walk you through the process and outline how it's going to work. But now is the time to become an EB5 applicant, because once you're in there, if they change the law, you'll still be safe. Mila, how are you, Mila? Mila has been amazing. She's been following us for years. One of our dedicated followers from the Philippines. You're amazing. Thank you, Blash Blash. Meha, can my husband and I anticipate an E2 visa by June of next year? Should we work with your offer now? Of course, absolutely. Right now, we are working with the London U.S. Embassy, and they'll be very cooperative with us. We have quite a few cases there. So if you start now, I anticipate that probably by early next year sometime, maybe by April, you should be able to get it done. So yeah, absolutely. Just send me an email or send us a private message on the Facebook page. And thank you for following us, because we don't take it for granted. Monica, thank you so much. Dale, thank you as well. And again, those of you that catch this stream not live, because those of you guys that are here live, we're going to know if you're live because there's a special red notification. But those of you that are going to watch this in an hour or two or tomorrow, you can continue posting your questions and we'll continue to answer them on the same thread. Or you can just send us a private message and we'll continue to answer. Marie, you had something to say about the fires, the wildfires in California, and how is that affecting immigration? Why don't you kind of share with us? And then again, any other questions? We have 5 minutes left on the live stream. We always keep it 30 minutes to respect the time of the attorneys and also your time. But remember that you can also, we have, I'm going to butcher that name, Algenero. Did I say it correctly? Algenero Erivode. What happened when your case is pending and you're no longer with the man? Well, if you're no longer with the man, there had to be a good reason for it, right? What did he do to you? Did he do something bad? Anyway, but aside from the fact that he's not a good man, if you're no longer with the man, if it's a first interview, so if you're doing a 45 adjustment and you're no longer with your spouse, the case will not be approved. It will be denied unless there is an abuse, or even an abuse. It's going to be very difficult in the beginning to do it. If you have your second green card, if you move to the second stage and you're no longer with that person, then there's a way to save it either by getting divorced, or if there's any other abuse cases. But if it's the first, right, Marie, if it's the first 45, if you're no longer with it together before the interview, it's very difficult to save it.
Yeah, we usually send our client and they do requests for an abeyance for 1 year, and because very often there is cases of abuse, serious abuse by the U.S. citizen, which gives us time to file a VAWA for a victim of abuse woman.
Correct. Does it make sense?
And we've been very successful.
Yeah. So basically, what Marie said, that's true. So if you're no longer with a man and there is an abuse in the relationship, then there is a way to save the case. And again, if it's a case-specific question, which I think it is, just send us an email or send a private message in the Facebook, and we'll respond to you immediately. We're going to say hi to Hilda Orzel. Thanks for watching. And we have a Gaspar Silva who has a question. My father put papers 15 years ago. He's an American citizen. I don't have, you don't have anything. So again, it depends on the priority date. It looks like you don't have any action on your case. Many times in those old cases, it could have been a situation where the petition is closed because there's no activity. So I highly encourage you to look at the case number and contact immigration and the MVC to see if your case is no longer active. Because if your case is no longer active, it's no point for you to wait 20 years or whatever it's going to take. You really have to check on the status of your case. So Gaspar, maybe you can tell it to him in Spanish because I don't think he understands English. Can you say it in Spanish, Marie? You speak Spanish, right? Marie speaks Spanish and French. Unfortunately, I speak only Russian and Hebrew, so yeah.
But you can go on the visa bulletin, type Google visa bulletin and look what is your priority date. Look at the date for a child of a U.S. citizen. It takes a long time.
Exactly. Look at the date. Monica has another question. Another question is for your cousin. My cousin brother was in the process to get his visa by way of his mother. His I-130 was approved, and she needed to send only financials. Unfortunately, his mom passed away in July. What happens to his case? So it's a good question, because there are some cases where, Monica, you can put a substitute sponsor. There's an act that came several years ago. It's called the Substitute Sponsor Act, and so he may still be able to save his petition by using a substitute sponsor, which could be a brother, sister, a parent. It depends on the case. I highly recommend your cousin to contact our office so we can determine whether a substitute sponsor can be applied, right? And that's a very good option because most people don't know about it.
Yeah, you have an I-130 approved, so you can reinstate it's called a humanitarian reinstatement. You're going to beg immigration to accept another financial sponsor than your mom. It can be a brother or sister, or your father, the father of this person. We've been very successful, but to tell you in advance, to reinstate the I-130 is going to take 2, 3, 4, 5 years.
Right.
It's worth it. We've only had success with that.
Exactly.
We bring back people because your I-130 is already approved. If it was before, if she had passed away before the approval of the I-130, it's almost impossible. But
so there's a way to save it. That's the bottom line, Monica. So please get in touch with us. We'll help you. Hilda Orzel has a question. Hello, Hilda in the Philippines. And Marie, Marie is married to a Filipino person. So we eat a lot of lumpia here because of Marie. I wish. Good morning here in the Philippines. I would like to ask if my husband can apply a petition here in the U.S. because his case can't travel alone because of his health conditions. So your husband is a U.S. citizen, my understanding, and he wants to file for you, the Filipino spouse. He can do that, and it's doable, but he's going to need to prove domicile in the U.S. at some point. So there are ways to prove it, and you have to consult with an attorney. But to answer your question, yes, if he's a U.S. citizen and he wants to file for you while in the Philippines, he can still do that. Oh, Julie Gordonio is here. Our favorite client, Julie. Bonjour, Julie. And Julie's asking, when will we have to think about our E2 renewal before expiration of the first one? Typically, Julie has been a client of ours and an amazing E2 applicant. We usually recommend clients to come to us at least 8 months before it expires so we can have enough time to discuss and plan the case. So I would say about 8 months before the end of your case, come to talk to us. And we usually say 2 years before, at least talk about it so we can tell you if your case is good. 2 years before it expires, if it's 5-year E2 visa, do a case audit so you have 2 years to fix it. But 8 months before it expired, come to us so we can help you renew it. And we wish you all the best, Julie, because you're amazing.
You have a great business, so I don't think you're going to have problem renewing it.
Exactly. Mukhtar is talking, hey, sorry guys, joined you now. So I don't know the topic. Can you please help me with the topic? So we talked about many things. We talked about changes in immigration, the DACA. We talked about more complicated matters in green card interviews. We talked about Trump and how amazing he is. All these things. But you can ask your immigration question. Even if you missed it, remember, the live stream will end and it's going to be a replay. So you can go back, scroll back and listen to the whole thing from the beginning. So you didn't miss anything. And the fact that you're here live, Mukhtar, is amazing because I can actually welcome you and say hello. Meha, you have a question, as a final question. Do you happen to know if I study with the U.S. as a spouse of my husband, whether I qualify as a U.S. student or am I still considered an international student? So if your husband has a student visa, you are his wife. You're an F2. So if you want to be a student, you have to have your own visa. All right? That's how it works. Gaspar, thank you. Dale here is, how viable is the change status to H-1B under H-1B cap-exempt institution with a few months left on OPT stem? If it's a cap-exempt institution, if you have a few months, I think it's very doable, right, Marie? We need at least 45 days to do it because we need time for the LCA. But make sure that we need to determine that it's truly cap-exempt. Some people think it's cap-exempt and it's not. So if it's truly cap-exempt and we verify it, you have time.
Yeah, and I see your OPT stem, so you're probably some kind of engineer or very technical, so it should be smooth. You just pay for payment processing. You're going to have to pay probably for payment processing.
Exactly. Just like I said, send us a message, we'll review it, and we're more than happy to work with you. And again, mention the live stream to get a special surprise. Monica, awesome. I'll have her contact you. Perfect, Monica. You're even more awesome than this. And then Julie, thank you, Julie. And then Meha, last final question, and then we're going to end the stream because 30 minutes, and we have to go back to work. Our clients are waiting. And again, guys, keep posting your questions. We'll go back to answer me and Marie. And last question of May. And does the U.S. Frown on bringing newborn children from the U.K. to the U.S.? Does it look negative to the application? No, of course not. As long as they're born in the U.K. and they can fly, you can travel, no problems.
As long as you have authorization, if you the dad or the
correct, if you can legally bring them here,
authorization on the person staying behind.
Exactly. If you can bring them legally, you can come there, no problem. Again, ma'am, make sure you send us an email, and I'll put my email again here, and I'm more than happy to help you with your E2 case, especially with London. We love this embassy, one of the best out there. Here we go. And once again, I want to thank you for watching our live stream, both from myself and from Attorney Marie. We're going to do it every week, as long as we're healthy and able to do it. And if not, we'll bring the computer home and we'll do it from home. But anyway, thanks for watching. And again, what we want from you to do, the ones that are watching the live stream, make sure you share it. There's a share button at the bottom. You can share it so everybody can see it, your friends. And if you can put a heart, there's a heart right there. You can put some hearts in there. And we'll continue to do that for you guys every Wednesday, 2 p.m. Pacific time. Our immigration live show, Ask an Immigration Lawyer. Both Marie and me are thankful for you. Karthik, let's see. Last question, I promise. Terminated May 19. He got new admission. He was thinking to cross the border. We heard the new rules there. So he has an international student. His service terminated on May 19. He got a new admission. You mean he has a new service? Well, that's a very complicated matter. And
you can try F1 reinstatement if it's been less than 5 months of overstay. If you have a good reason why he lost his service in the first place, was it a mistake from the school, or was it like he messed up, he didn't attend school? That's if you have a good reason, it was the school messed up. You can try reinstatement. Otherwise, yes, the new rule, the new memo. You start August. Well, what day are we? August 9, he's going to start accruing unlawful presence, yes.
Tomorrow. So tomorrow is the last day for students to accrue unlawful presence. And we've done a video on this in our YouTube channel. And we talked about it in the live stream last week. So go back to our live stream last week and you can hear about the changes for students. Anyway, guys, thanks for watching. Peace and health and love from San Diego. And we'll see you next Wednesday. Right?
Bye.
Bye. And...